70% of all prisoners, they are all awaiting trial. That is quite the number. What do you feel could be done to reduce this?
Yes, prison congestion is a hydra-headed problem. It's not one thing in particular that you say is the reason why we have so many people. Of course, the percentage you gave there is quite high. First and foremost, we have not built custodial centers, prisons. So in the past 40 years, what we have mostly is a bequest from the colonial era. Most existing custodial centers in Nigeria today where things are places, facilities that were handed over to Nigeria at independence by the colonial government. How many new facilities have been built between 1960 and now? How many of the existing ones have increased their holding capacity? Few, if any at all. Now, within this period, population has increased geometrically. Economic activities have increased, giving rise to issues. At the same time, living standard of people have steeped, has gone downwards, giving rise to crime. Now, what happens is that there is a pressure on the existing systems. So, to put people in there is easy, but to get them out now becomes a problem. So, now let's go to the question. Awaiting trial inmates are the people, the category of inmates who supposedly should have their trial going on in courts, but they are not, for one reason or the other, out on bail. Some of them have been given bail at the magistrate court, but no one to come forward to stand as surety for them and perfect their bail conditions. There are some offenses that it's not that easy for the court to grant bail. Now, these ones are in custody and attend trial. Now, get to the trial proper. What are the reasons that we have this slow or snail-like speed in trial, in criminal trial process? One, let's start from prosecution. You get to court some days, you see that the witnesses that are supposed to attend the trial, give evidence, are not in court. So whoever, an inmate that is brought from custody to court that day, has wasted that day. He's going back to custody without his trial making progress. That's one. Two, we have at times or sometimes the absence of the judicial officer. Without notice, you get to court sometimes and you hear that the court will not sit. In few instances, you are told why. In some other instances, you don't know why. If an inmate is brought from custody, that day has gone. So he goes back without any progress in his trial. The other instance is where also the inmate may not have a lawyer, a legal representation to stand for him, and there is a whole lot of difference between an inmate, a defendant who has a lawyer defending him, and one who doesn't.
Well, is the government not supposed to provide an attorney for whoever is not capable of finding one to represent him? Presently,
like in Lagos, you have the OPD, Office of the Public Defender. By rights, they give lawyers, attorneys to represent these defendants, but it is a particular class of offenses. When you talk about the magistrate court offenses that can be tried at the magistrate court, stealing, pilfering, affray, it's not that easy for the government to provide lawyers for all these. But when you get to robbery, murder trial, indictable offenses that are triable by information at the High Court, the government provides lawyers for this set of people. But they are not the only people in custody. These other people who don't have lawyers are there. The number of lawyers needed to do this, the government cannot come up with it or has not come up with it. That's why you have now the Legal Aid Council of Nigeria. You have other organizations like ours that step in from time to time to close that gap. Even with that, it's still not sufficient. So sometimes you get to court, these inmates that don't have legal representation, and and when a lawyer is not defending a person, the case is called, it's like you're a neophyte, the person is a neophyte, it's a layman in language and procedure of court. Whatever goes on that day, definitely most of the time, it is an adjournment that the case will suffer, except if the prosecutor has come up with witnesses. Some magistrates at that level exercise their discretion and go on with the case. After a couple of adjournments and the prosecution is not ready to move on with trial, the magistrate will strike out the case. This happens in some occasions, not all the time. So the absence of defense lawyers, even when defense lawyers are in court for a person, some adjournments that the lawyers make are not proper. The cases keep lingering. This is another cause of congestion in our prisons. Okay, you can go on and on and on, and you see that by the time these factors merge, it becomes a problem for the justice the wheels of justice to move as effectively as it should be. Meanwhile, when this is going on, a lot of other people are being arrested, they are being remanded in custody, and the facilities keep, increasing to a point where it becomes virtually impossible or difficult for any other person to come in.
Yes, that is quite sad. But this makes me wonder, is there a particular number of correctional facilities each country is supposed to have? And is it that Nigeria is not meeting up to that standard, or we just have so much people committing crime in the country?
No, actually, there is no law that says a country should have a particular number of correctional facilities. Don't forget that countries have different population statistics. Nigeria is quite populated as a country, and that doesn't translate outrightly to high crime rates. But what we see, like I said earlier, is we have not increased the number of custodial centers. Presently, we read in the news that the federal government is constructing 6 new additional facilities. 3 of them are at advanced stage in different parts in the country. And we understand that each of them will hold a maximum of 3,000 inmates. Of course, that is something novel, that's something new. But when you talk about custody or these custodial facilities, you get to see in the main that we should also begin to think outside the box in terms of what are the kind of cases that should even go to court. 2 people are fighting on the road, you get them arrested, you charge them to court. Should that be? Now in criminal justice, you even have mediation. The advanced countries, and of course it's coming into Nigeria. It's in Nigeria now. Advanced countries sit the parties down and try to discuss and see how can we settle this without the courts taking over the matter. Lagos State, for example, has something they call district attorneys. These are lawyers from the Ministry of Justice that are posted to magistrate court districts. When the police bring charges to file in court, they go through the charge. They call the defendant and the complainant if it is sort of such a nature that the feel should not really be taken for trial or should go into the court and be charged as a case in court. And if such people can settle at that point, it's a win-win. Okay? In some other cases, they just tell the IPO, look, this charge will not stand. Go, release the defendant. That's something good. We should do that and do more than that, so that the kind of cases that should even go to prison or for trial, we should know them. Look at something like environmental sanitation offenses, environmental as they call it, the one that they kick against indiscipline carry officers and superintend over. People are selling on the street trading. There is a law against that. Now you arrest the person, you take him to a mobile court, he pleads not guilty, or guilty as it were, and he doesn't have the fine to pay. He's taken to the prison. Is that a criminal offense? No. These are categories of offenses that are called civil offenses. Just like when we used to have restrictions on environmental sanitation days, And when you break that restriction, or when a person breaks that restriction, he or she is arrested. Some of them have ended up in prisons. We've met quite a number of them.
And this brings to mind now people who are in prison. I don't know if the word you use for that is unjustly, even though they've committed a crime or not, but it's not one that should have landed them in prison. But then we do have them in prison. And from what I've learned, some spend 15 years in prison. How is it even like there for these people? Since you're a lawyer that is handling cases like this, how is it like for the people? Let's look at it from the human angle perspective. Being in prison for 15 years or more for a crime you didn't commit, or for one that should not have even landed you in prison in the first place.
Yes, sadly true. Sadly true. I have encountered, our organization, we have encountered so many people. Now there is something about crime and the trial process. Justice is even, it's a balanced thing. We always say, he who alleges must prove. He who says, he who pronounces must show. If you allege that this man committed a crime, you've arrested him, the law is that you should bring him to court, commence his trial, supply the evidence. The court will do the right thing. But the situation where people are arrested, you come up with the charge, these are robbers. Yes, there is armed robbery, there is murder, no one is denying that. But how has the law set the process to be for someone to end up being called a murderer in the eye of the law? That is at the point of conviction. This is the law. We can't change it. When we got to school, they taught us this and they told us so much more. That it's not just for you to say, this man committed the offense. It's even more for the person that said so to go to court with the evidence, present it before the judicial officer. Now, if a person hasn't done that, arrested a suspect, take him in there, now the suspect waits. Like the category of the instance you just gave, which I said we have seen in practice. These are instances where people are arrested. This category of offenses are indictable offenses, we call them. The offenses that are triable by the high court: robbery, armed robbery, murder. Now, they are remanded in prison custody by the magistrate. The magistrate doesn't have the jurisdiction to try this group of offenses. So when they are remanded, the next thing that should happen is that their case file should be duplicated by the police and sent to the office of the Director of Public Prosecutions, DPP, who issues a legal advice based on what is in the file to now say, oh, with the evidence we can see, the suspect should be charged for this offense. Now move his file so that we can arraign him at the high court. Or the advice can come out and say, no, there is nothing in this case file that discloses the kind of offense you have arrested him for. If this matter goes on for trial, you're going to lose. So the advice will say, release him. Okay? But what we have met over the years that has culminated in the kind of thing you said is a situation where people are arrested, the duplicate case files which should be forwarded to the office of the DPP, the files are not forwarded by the police. The person is in prison custody. Don't forget, he's not entitled to bail at the magistrate court level. The magistrate cannot exercise. Of course, in the new law now, a magistrate can do that, but many don't do that. We have, in our organization, some years back, we encountered a young man who had stayed 12 years in this category, awaiting trial. In fact, not awaiting trial, awaiting advice, whether he is going to be tried or not. So he's not even technically supposed to be called awaiting trial, in my view. He's awaiting the advice of the DPP to now know whether he should be tried. What if after 12 years and the advice comes out and says, no, there is no offense disclosed from the file. the young man goes, which is what happened in our case. Just that the DPP didn't, the file wasn't seen. In other words, along the line somewhere, the police misplaced the file. We met him, we met others of 10 years, not one, not two. We met 8 years, 9 years. As we speak now, there are inmates in Lagos, I'm not talking of other states, there are numerous of them, in Lagos who were arrested in 2009. Now we have an application at the High Court where we have inmates who were arrested in 2012, about 5 of them. The application is pending now in court.
That's 10 years.
It's 10 solid years.
Okay, so after these people, let's say for example, the man that was awaiting advice of the DPP, sure, and then it came out that, okay, this person should have been released and there's no need for trial. Is there any compensation for wasting 12 years of these people's life? Absolutely.
This is the aspect of law that, you know, organizations like ours and others should push forward. For there to be something. Now, if the person is released under the Fundamental Rights Enforcement Procedure, that procedure says an apology will be rendered to him, some money will be paid to him. Of course, the court has to decide. So you take the application to court under that process, under that procedure, then the judge will now, if a judge ends up seeing that, oh, their rights have been infringed, okay, their rights were breached, their fundamental rights were breached, and they ought to be released. That order for release should normally come, according to the law, with apology and with compensation. So in all these cases, we applied for some money for compensation. But that is in this procedure. In other instances like the one you've mentioned, and some others we encountered where somehow like the state chief judge decides to come up and say, okay, let's get this place decongested. And organizations bring applications and then they are released. There is no compensation. This is an aspect of our law that has to be taken care of. Even more so, what should be the lot of the IPO, the investigating police officer or crime officer in whatever law enforcement agency that brought about this? Because the law is that after you've arrested, you've taken to court and the magistrate has remanded the person, the file, like I said, must go, should go. If that file doesn't get to that office, someone somewhere has to bear the brunt. Something like that has to be enforced also. So people, you know, will know that impunity doesn't pay. Impunity will be checked. People don't just do things because you're putting on a uniform or you're on one exalted office and you think nothing can, or the person thinks nothing can happen to him. So for now, there is no compensation except you go to court, perhaps challenge the system and say, look, I've been here for 15 years, 12 years, 10 years. I'm supposed to have something. You can't waste 10 years of my life and expect me to just go. And at the end of the day, tell me, oh, bye, we are sorry, and blah, blah, blah. No. And that is unconscionable in my view. That's part of the reasons we keep canvassing for more reforms. Our nation cannot be a nation to be proud of in the Committee of Nations if this kind of practice still goes on. And sadly, it still goes on. I just said to you, we have applications pending in Lagos State. What about other states? Even where the DPP's advice, the file gets to the office. We've canvassed that speed should attend, you know, the dealing with of those files. Those files should be handled expeditiously. You don't just get files, keep them, the civil service bureaucracy takes over. The person comes to work in the morning, goes in the evening. No, you are handling sensitive cases. And if the manpower is not as it should be, volunteers should come in. Organizations like ours can volunteer to be part of the team to assist in getting legal advice. Just let it be a confidential thing. At the end of the day, you pass it to the superior officer who is a full-time staff to go through. Say, okay, yeah, this is good. And the instruction goes out. Charge him or release him. A situation where even the advice, we are waiting for it for 1 year, 2 years, it's not right. It's not right.
That is indeed sad. And going by what the AGF said, that other forms of punishment are now allowed apart from sending them to prison. But from all the explanation you've given so far, like they'll first of all stay there for a while, awaiting advice, awaiting trial. Do you see that happening? That is what the AGF said, that other forms of punishments are not allowed apart from sending them to prison. How would they even determine the type of punishment to give the person if it has not been proven that this person committed so and so crime?
You know, one thing in law or in crime and criminal justice is that it's something that in the Constitution, the states also have the power to prosecute, not just the federal government. So the AG of the Federation is speaking at the level of the federal government. The states attorney generals also have their own remit. Now, there is no way imprisonment can be the only thing. I'll give you an example in Lagos, which in my view is ahead of so many other states. We have restorative justice, the mechanism whereby we look at how can we restore the victim to his position. What you call plea bargain, for example, is part of that. Now, imprisonment, even in some other crimes, is no more the way to go. Because at the end of the day, you notice that even imprisonment doesn't help the individual. Okay? There are other things you can do. The mediation or alternative dispute resolution aspect of criminal justice can come in. And then you also have community service, whereby a person is convicted but told to go and work in a government place, do menial jobs, sweep the roads, you know, do such service without necessarily going in to the prisons to serve time as a convict. These are the things that one should encourage, okay, and not say there are no other forms of punishment allowed or encouraged except, no, that you can say that at the federal level, but at the state level, states like Lagos State are looking beyond imprisonment, which is the way to go internationally. Because if your facilities are not helping, you go to the custodial center because of the congestion. If a budget was made for 100 people for 1 month, and in that 1 month they see 500 people, how does the money come about? Nigeria operates the federal structure, and prisons, corrections is in the exclusive list, which means no state runs prisons, no local government runs prisons, no individual can set up a prison, no organization, as opposed to what you have in the US or South Africa. That means the budget for a year for every prison is kind of cut out at a particular, with a particular statistic in mind.
But do you feel that would be solved if the prison establishment is put on the concurrent list?
Absolutely. We are the forefront, or part of the people are the forefront of saying, look, we are dealing with human beings, not animals. There are aspects of our federation that we should look at restructuring. This should be part of what people, you know, who are conversing for restructuring should also look at. This, for us as an organization that is focused on this aspect, we believe there should be devolution of powers. That prison should leave the exclusive list. Let the federal government keep few of them. You may call them the marks, as they do in the US, the very maximum security ones for a particular kind of offenders. But the other ones, let the state governments come up with ideas on how to run them. So that rehabilitation, which is the real essence of imprisonment, can be achieved. If there is no rehabilitation, what we only do is to keep people there and breed group of gangsters who end up in the society to commit, you know, bigger crimes. Even the innocent ones who stay with the hardened ones end up no more being innocent. When they go out into the society, they are grieved. I didn't do anything. This man arrested me. I stayed there 5 years, blah, 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 blah. And that is it. So if we don't look at If you don't look at the system well, from the view of corrections, it's now the Nigerian Correctional Service. If we don't look at it purely and work on it, not just look at it from that angle of corrections, rehabilitating the person mentally, physically, empowering him with some skills, but by the time he gets out from prison, he can add value not just to his own life but to the society. If we can't achieve this, let's begin to look less at imprisonment and then know other options to deal with offenders.
Yes, because this brings to mind when prison decongestion is about to take place and then they set some criminals free, or maybe the ones that have been there for a long time. But what are the steps? Do they even take any steps to find out that, okay, releasing this person back to the society would not cause nuisance, would not add to the problem that the society is currently going through? Because when we get prison decongestion, they are freeing people who have been there for a long time. Does this mean that decongestion should go hand in hand with rehabilitation?
Yes. When you hear about official decongestion, you notice that not everybody benefits from that. Sometimes you hear a number, 20 people. This, for example, 20 people, 30 people. This number must have been vetted. For example, there is no reason why a person should be awaiting trial beyond the length of time the law prescribes as punishment for that offense. The person committed an offense and the law says 2 years if found guilty. But here the person is staying 1 year, 8 months, 2 years, few months, awaiting trial for an offense for which if he were to be convicted, he will have 2 years. Definitely the decongestion process or program will benefit this kind of people because the law has given him a leeway. Now, that is to buttress the fact that not just everybody benefits from that. So in a sense, we are not going to say criminals are being released. But on the other sense, from what you've said, yes, mere going in there with what obtains. Sure, we are not going to stay on live TV and say that there are not people who committed the offense for which they are being held. Some of them are hardened fellows. But as lawyers, remember, we also always say, prove it, and that will be all. So that he also will know that he or she is serving time for that offense. Not to keep him indefinitely, 10 years and all that, okay? So, if a group is being released, they ought to also go with value or with empowerment. You should have empowered the person. That is what you're talking about, rehabilitation.
Yes.
Remember, for me, rehabilitation is 2 parts: before release and after release.